Kate, whenever you are ready.
Welcome to today's program titled The Year-End Paid Sick Leave Playbook, 2025 Recap and 2026 Forecast. At this time, all participants are in a listen-only mode. For those of you who are logged into the live web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, later in the presentation, we will read the CLE attendance verification code. Please write this code down, as it will not be reread and it is required on the CLE credit request form. During the program, you will also see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can find this link to the form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees within a day or two following the webinar. On the next slide, you will see a legal disclaimer. And with that, I would like to turn it over to our first speaker for today's program, Josh Seidman. Josh, please go ahead.
Thank you, Kate. Hi, everyone. Good afternoon. Wonderful to be here with you for today's year-end wrap-up paid sick leave webinar. This is our second paid leave webinar of the week. We did a wonderful paid family leave deep dive digest on year-end and wrap-up and forward-looking into 2026 just a couple of days ago for anyone who might have missed that one. And today we have a ton of content to get to. So I want to quickly introduce the team that is joining me today. We have myself, Joshua Seidman, great to see you all, Kathy Feldman and Katie Graham-Perot, our fourth team member, Ashley Casey, hopefully be joining us as well in a little bit later on. We are all counselors nationwide on these complicated paid sick leave laws, so it's great to be with you all today. Next slide, please. Here is our jam-packed agenda. I'm not sure we could have fit another line on this agenda slide, so lots to cover today. We're going to start with a brief national overview of paid sick leave and paid time off laws. We'll then jump into Nebraska's paid sick time law, a look back on the newest law to go into effect in this space. We'll then turn to Alaska's paid sick leave law, which is less than 6 months old as well and has some recent activity in terms of administrative materials there. We'll then talk about California, New York State, and New York City activity, big Pittsburgh amendments that start in just a few weeks, Minnesota and Minneapolis updates. We'll then remind folks about Missouri's paid sick leave law or lack thereof, Maine paid time off law amendments, and then we'll wrap up with a couple of updates that are dropping at the beginning of next year in Oregon and Washington, and finally a outlook for 2026. So lots of ground to cover. We're going to jump right in. Next slide, please. And one more. All right, so this is one of my favorite slides. We refresh it, year after year, program after program. So the first 16 versions of this webinar series had a similar slide to this, but we refresh it for every webinar. And this year, what you'll see for this cycle, we have a total of 56 paid sick leave and paid time off laws in the country. You do the math across the three rightmost columns, and you'll notice that the math doesn't add up, right? Federal plus 21 states plus Washington, D.C. plus 25 municipalities does not equal 56 total mandates. The reason is because there are multiple jurisdictions that have multiple mandates that fall under the paid sick leave umbrella. When we talk about that umbrella, we mean paid sick leave laws, paid sick and safe leave laws, paid safe time only laws, PTO laws, combo PTO paid sick leave laws, public health emergency leave laws, paid prenatal leave laws, right? A lot of ground to cover, as I said. When you add those up and you look at a place, say like Colorado, where there is both a paid sick time mandate and a paid public health emergency leave mandate, or New York, where there is paid prenatal leave and paid sick leave, you get the math that adds up to the total of 56 mandates in this space. The numbers are constantly changing, ebbing and flowing. During the COVID days, almost 5 years ago to the date, there were approximately 69 total mandates in the US. A lot of that driven by temporary COVID-specific paid leave laws, but no more of those around these days, thankfully. So the jurisdictions that are highlighted in that darker teal font on this slide are the ones that we're going to be focusing on today. Again, lots of activity in multiple of these jurisdictions, including several like Oregon, like Minnesota, like Washington, that have had multiple effective dates for different amendments over the last 6 to 12 months. So with all that being said, we are going to jump right in. I'm going to turn it over to Katie to start us off with Nebraska paid sick leave activity. Next slide, please.
Hey everyone, my name is Katie Graham-Perot. I'm an associate in our Atlanta office, and thanks so much for joining us today. I'll kick it off with talking a little bit about the newly effective Nebraska paid sick time law. And as many of you know, this law went into effect recently on October 1st, 2025. And that came after voters in Nebraska passed a ballot initiative for paid sick time back in November of 2024. And since then, there's been a recent flurry of activity as the Nebraska Department of Labor got ready for the October effective date. The law was amended significantly in June of 2025, and that was followed by frequently asked questions that were released by the Department of Labor in August, and then a guidance document that resembles rules and regulations in many other jurisdictions that was released in September. And then September 15th, the law's notice and posting requirement went into effect, followed a couple weeks later by the law's effective date. And one interesting note here about something that hasn't quite gone live yet, but the Nebraska Department of Labor is keeping a public enforcement website with a wall of shame, as we like to call it, where they will list violators of the law publicly for anybody to see. We haven't seen anyone listed yet, so we don't believe that that's totally live, but definitely something to keep your eye out for. Next slide, please. So digging into the details of the law and the recent amendments and guidance regarding employee and employer coverage first, one of the major amendments involved employer coverage, and specifically the act only applies to employers with 11 or more employees, but there are reduced paid sick time obligations for small businesses, which is employers that employ less than 20 but more than 11 employees. And notably, in counting the number of employees, the Department of Labor only includes individuals who work in the state of Nebraska for 80 or more hours a year. Next slide, please. So regarding employee coverage, most employees are covered. However, the amended act added several exemptions for certain groups of workers. Those exemptions include individual owner-operators, independent contractors, seasonal or temporary agricultural workers, and workers under the age of 16. And again, an employee is only covered under the law if they work in Nebraska for at least those 80 hours in a calendar year, regardless of whether they are a full-time, part-time, or temporary employee. Next slide, please. And regarding the accrual and year-end carryover requirements, accrual began on October 1st, or it will begin after an employee has completed 80 hours of consecutive employment, whichever is later. And under the law, eligible employees must accrue at least 1 hour of paid sick time for every 30 hours that they work. Accrual is capped at either 40 or 56 hours a year, depending on employer size, and all accrued unused paid sick time must be carried over from year to year. However, employers can avoid that carryover at year end if they do two things. One, pay out the accrued but unused paid sick time at year end, and provide the employee with a sufficient upfront grant of paid sick time at the start of the new year, or in other words, front load that time. Next slide, please. Regarding the annual usage cap and front loading requirements, regardless of the amount of paid sick time that is accrued or carried over at year end, an employer in Nebraska is not required to permit an employee to use more than 56 hours of paid sick time in a benefit year. And if you're a small business, that number is limited at 40 hours per year. And again, as we mentioned before, front loading is allowed. Employers can provide that total amount of paid sick time to employees upfront at the beginning of the benefit year in lieu of following the accrual. Next slide, please. So what reasons can a Nebraska employee use their paid sick time for 3 reasons. First, for their or their own covered family members' illness, injury, health condition, which also includes preventative medical care. Second, to attend a meeting at their child's school or place of care dictated by the child's mental or physical illness, injury, or health condition. Or finally, for certain public health related emergencies. And under the law, a covered family member includes a number of folks, kind of the typical ones that we see, including child, stepchild, legal ward, or child to whom the employee stands in loco parentis, the parent or legal guardian of the employee or their spouse, a person who stood in loco parentis to the employee or the employee's spouse when the employee or their spouse was a minor, the spouse or domestic partner of the employee, the grandparent, grandchild, or sibling of the employee or the employee's spouse, or any other individual whose close relationship with the employee is the equivalent of a family relationship. Next slide, please. So finally, we wanted to make everyone aware of the balance notification and notice and posting requirements under the law. The balance notification requirement means that certain information must be included either in, on, or attached to an employee's paycheck. And the notification must include certain information, including the amount of paid sick time that's available to the employee, the amount of paid sick time that's been taken by the employee to date in the year, and the amount of pay the employee has received as paid sick time. And the FAQs let us know that this requirement can be satisfied using an online system to which employees have access. And regarding notice and posting, as of September 15th, employers must provide written notice of certain topics regarding paid sick time at commencement of employment, and they must post notice in a conspicuous and accessible place where employees can receive information about the paid sick time law. And if the employer doesn't maintain a physical workspace or an employee works remotely, the employer can post the notice and posting through like a web-based or electronic platform or through electronic communications. So that is some of the highlights on the requirements under that new Nebraska paid sick time law. And I will now pass it on over to my colleague Ashley to tell us a little bit about what's going on in New York. Oh, I'm sorry, to Kathy to tell us about Alaska. Stay tuned for New York. Thanks.
Thanks, Katie. And we can go ahead and move to the next slide. My name's Kathy Feldman. I'm going to be walking us through some Alaska developments. We're going to start with the basics of the law, which went into effect July 1st, 2025. And in a slide or two, we'll jump to some of the new regulations that went into effect more recently. So starting off with kind of the nuts and bolts. Employer eligibility is expansive for the Alaska sick leave law. It applies to all employers in Alaska. Employee eligibility is similarly very expansive. It applies to essentially everybody with pretty limited exceptions. Really, the most notable exception might be minors under 18 that work less than 30 hours per week, but the other exceptions are really nuanced and likely not something anyone on this call will need to worry too much about. The amount of leave is something we're going to circle back to when we're talking about the regulations, but we'll note here that paid sick leave accrues at the rate of 1 hour for every 30 hours worked, which is a pretty standard accrual rate that we see in a lot of jurisdictions. The maximum annual accrual is either 40 hours or 56 hours per year, and that's depending on the employee headcount. So if an employer has less than 15 employees, it's the 40-hour cap, and if they have 15 or more employees, it's the 56-hour cap. Similarly, there is an annual usage cap that's the same as the accrual cap of 40 hours or 56, depending on employee headcount. And a really key point for Alaska, there is no carryover cap. So whereas a lot of jurisdictions we see some reasonable caps placed, in Alaska, all paid sick leave will carry over at year end. And there is a requirement to provide notice to your employees of the paid sick leave law. There's no model notice, as we say on the slide, and employers are not obligated to create their own notice, but there is still practical compliance required under the regulations, that you provide a written notice, or incorporate that into your handbook and your policies. So we can move to the next slide, and we will jump into some of the fun new regulations that went into effect on September 25th of this year. So the first thing we're going to tackle is that employee headcount, where we were talking on the prior slide about whether or not you've got 15 or more employees or less than 15 for those accrual caps and usage caps. In the new regulations, they give you the calculation that will determine your head count. So that size is going to be based on the number of full-time equivalents employed during the prior calendar year. And that terminology, full-time equivalents, is a little bit funky, but what it really means is the calculation that you're going to use, which is what's shown on the slide there, the total number of hours worked by all part-time and full-time employees during the prior calendar year. You're going to add those all up, divide them by the maximum amount of regular hours for a full-time employee during the year. And so there's two distinctions I just want to call attention to in that. For the first piece of the calculation, where you're adding up hours worked, you're including part-time and full-time employees. But when you're then dividing that by the regular hours, you're only looking at full-time employees there. So that's just a little nuance in the calculation that I think is worth paying attention to. Another thing that the regulations specified is that it is permissible to allow employees to cash out their paid sick leave at year end or at separation of employment, but that cash out has to be optional, and there's certain requirements that have to be adhered to in order to confirm that it's an optional cash out and not something that's required by the employer. So first, employees have to be expressly given the option to take the payout instead of carrying over yearly, or if it's at separation, have the option of cash out rather than maintaining the balance in the event that the employer returns to employment within 6 months of separation. The second piece is there has to be written voluntary acknowledgement of the acceptance of the cash payout. So those are two things that we don't see in a lot of jurisdictions, so important to pay attention to for Alaska. Another thing that the regulations did was they clarified that paid sick leave can be front-loaded in Alaska. This was something that was a bit of an unknown before the regulations. And the front-loading will eliminate carryover. Another thing that happens when you front load that's different in Alaska than some other jurisdictions is you can prorate part-time employees front-loaded grant based on the number of hours that you would anticipate the employee would accrue based on their normal scheduled hours. A lot of jurisdictions don't specify anything regarding proration of part-time employees, so that's a nice addition we got for Alaska. And we can go to the next slide to talk about a few other topics that the regulations addressed. One is the employee notice to the employer of their need for sick leave. So here we've got a limitation that employers cannot require more than 10 calendar days advance notice for foreseeable absence. We've seen in other places where no date range is specified, and some other jurisdictions where it's maxed at 7 calendar days, but 10 days for Alaska. And as with a lot of other places, Alaska employers can require notice as soon as practicable for unforeseeable paid sick leave absences. We've also got confirmation on the rate of pay for sick leave under Alaska law, that it's going to be the regular rate of pay. Again, something we see in a lot of other jurisdictions, and good confirmation that that's what applies in Alaska as well. And finally, the regulations confirmed what has to be included in a written policy or notice. And so those topics are all listed here for you on the slide, but it's the entitlement to paid sick leave beginning at the outset of employment, the relevant accrual rate, reasons for use, and if an employer is using a PTO program to satisfy the sick leave requirements, that has to be specified in writing, as well as the notice and verification requirements and a prohibition of retaliation against employees' lawful use of sick leave. So a pretty robust notice or policy requirement there, and something to pay attention to for compliance with the Alaska law. And with that, we're going to move to another jurisdiction, California, which loves to change its sick leave law every single year, it feels. So this year we actually have fewer changes than we've seen in the past. We can move to the next slide. We're going to take a bit of a look back at some of the changes that went into effect for January 1st, 2025, which I know feels like a lifetime ago. But the changes that are going into effect for January 1st of 2026 relate to the 2025 changes. So figured it was worth a bit of a refresher for you all. So beginning on January 1st, 2025, the California legislature amended the sick leave law to clarify that paid sick leave can be used if an employee is a victim of a qualifying act of violence. And that would apply for employees no matter the headcount. But then if an employer has 25 or more employees, an employee can use paid sick leave if they or their family member is a victim of a qualifying act of violence. And we're going to get into some of the different reliefs available that they can use that time off to obtain. But this was a pretty big expansion. The safe time reasons for use prior to 2025 in California were limited to domestic abuse, stalking, and those same type of offenses that we see in a lot of other jurisdictions as well. And qualifying acts of violence, as we'll show you in a later slide, is a much broader definition. So this was a pretty big expansion of the safe time reasons for use in California. And we can go to the next slide to talk just very briefly about the plethora of available relief that's available to employees when they're using sick leave for qualifying acts of violence types of occurrences. So you can see here that there's these 10 additional categories of relief that they can work to obtain for employees working for employers who have 25 or more employees. And it's much more extensive than it was previously under the prior safe time reason for use. So now we're going to move ahead to 2026, and on the next slide, take a look at the new addition to the safe time reasons for use of sick leave, and that's for victims of certain crimes. And again, this goes into effect in just a couple weeks on January 1st, but employees can now use sick leave to take time off to attend judicial proceedings if the employee or a covered family member are victims of certain crimes. And we're going to talk about what those crimes are again in just a minute here. A few things, though, to take note about what this covers. It specifically covers attending judicial proceedings. So it's not just leave for any reason or leave for a broad category of relief like we saw with qualifying acts of violence. It's much more narrow scope than that. And judicial proceedings is defined under the law as any judicial proceeding. There's really no limitations, but generally something that is related to the crime or the offense. And this new reason for leave, like qualifying acts of violence, is also covered under California's unpaid job protected leave. So it's not purely a paid leave provision. There are two kind of tiers of leave that employees can take: paid sick leave or the unpaid job protected leave. And on the next slide, we're going to talk a little bit about the definitions at play here for both of these two safe time reasons that we've been covering. So qualifying acts of violence, as I said, it's an expansion of the domestic violence, sexual assault, and stalking definition that California previously used. And you can see on the slide there where they've expanded it into these additional 3 sub-bullets. So important to note there that if an employee puts an employer on notice of anything that falls under this category, qualifying acts of violence would be in play. And for victim of a crime, we've got the definition up there for you as well. And as you can see, there are 11 different crimes listed under that second bullet point that count as what of being a victim of a crime could amount to, as well as a few additional definitions under the first bullet. So even though it's a more nuanced area, because it's relating specifically to time off for judicial proceedings related to these crimes, it's still expansive in the types of crimes that California is looking at. One thing not noted on this slide, in 2025, California required a model notice be created relating to the qualifying acts of violence leave, and that is a survivors of violence and family members of victims right to leave and accommodation. Say that 5 times fast. So that notice is available, and everyone should be distributing that to their employees at hire and annually. It's unclear if that notice is going to be updated to include this victim of crime addition from this year. The law did not specify that any modifications were required. So it's important that even if you're utilizing that notice, as you should be for qualifying acts of violence, that your policies are still addressing both qualifying acts of violence and victim of a crime safe time reasons for use under sick leave. And we will see what California does next year. It's always a mystery. But now we're going to move over to a state that did a lot more this year than California, and that is New York.
Thank you, Kathy. Hi again, everyone. Appreciate folks sending over their questions as well. There was one question that came in about Alaska that is a good one, and one that has frankly irked me about many paid sick leave laws over the years. The question about, like, why would the state allow year-end carryover of no cap, right? But limit annual usage, and especially when there's no obligation to pay out the time upon separation of employment. So it is very, possible, right, depending on the amount of time that an employee rolls over, that they could have an overall balance of sick time that exceeds the 56-hour annual usage cap, if that's the cap that applies to you in Alaska. It is part of a technical compliance, part of the risk assessment that companies need to go through when they're weighing the programming challenges, the potential for employees and managers and HR to get confused by the different banks, and having more in your bank than what the law allows you to use, versus technical compliance. So Alaska is not alone by any means. New York, frankly, falls into that bucket too. New York State paid sick also has no cap on year-end carryover, but a 56-hour annual usage for large employers. So that is a frustrating part for sure. We will thank you for sending in the question. We'll continue. We should have a few minutes at the end to go through some more of the questions from folks. So we'll try to type out some of our thoughts, but also save a couple of minutes on the back end to talk through a few more of those questions. So thank you for sending them in. On to New York. So as Kathy said, lots of activity in New York on the paid leave front this year. If you go to the next slide, the piece of good news, I suppose, that we can relay today is the COVID-19 paid sick leave law that started in March of 2020 sunset at the end of July of 2025. It was the last COVID-specific paid leave law in the country by several years. So it is nice to see that it has finally been sunset and wound down. So just as a reminder, that final bullet point here, to the extent an employee does have test positive for COVID-19, or a covered family member in New York test positive for COVID-19, or they're out getting a test to determine if they're positive, right? Any of those things, right? Preventative care, right? Or the actual illness, those are all still covered by the general paid sick leave law in New York State and New York City. So employees should be allowed to use their available banks of time under those laws, just as they would for any other illness, injury, health condition that might arise. So next slide, please. A big topic that has had a lot of employers reach out to our team for counseling support throughout 2025 has been the topic of paid prenatal leave. So this is technically part of the New York State paid sick leave law, but is a standalone mandate, right? Is a separate part of the law from the general paid sick leave component. This slide gives you a timeline of what the activity involving paid prenatal leave in New York State and, as of July of this year, New York City looks like. So New York State initially passed this law, this mandate, as part of its financial package in 2024. The first set of guidance that came out was in late December of 2024 through FAQs. The mandate technically took effect on 1/1/2025, and then, not to be outdone, because New York City does like to be more expansive in certain ways with its paid sick time law as compared to New York State, in May of 2025, the New York City Enforcement Agency, the Department of Consumer Worker Protection, released FAQs. There was guidance and updated rules that were enacted in early June, and then a few weeks later, on July 2nd, New York City's version of the paid prenatal leave mandate went into effect. Now, This is part of the New York City paid sick leave law. It very much overlaps with the New York State paid prenatal leave mandate, but there are several notable differences that we'll get to in just a couple of seconds. And then a few months ago, on October 25th, New York City amended their paid sick leave ordinance to codify the paid prenatal leave. Prior to that time, it had only been in the rules of paid sick leave, not the actual ordinance itself. Next slide, please. So talking through some key provisions, this slide is really meant to focus again overlaps between New York State and New York City on this topic. So the definition of employee, it's broad, full-time, part-time, temporary, private sector employees, generally speaking. Employers, you have one or more individuals in the state, you're going to be subject to this mandate. It is 20 hours of paid leave during a 52 calendar week period, and that calendar week period is a look forward, right? It begins when the employee first uses the paid prenatal leave. A big wrinkle that we've gotten a lot of questions from companies about involving this law is simply that both for New York State and New York City is also 20 hours, right? So as long as you're complying with the most favorable parts of both, you don't have to give a 20 plus a 20 for 40 hours of paid prenatal leave, right? But both of those laws generally say, the New York State and the New York City versions, that these are in addition to any other paid or unpaid leave entitlements that the employees receive. So they're certainly in addition to New York State paid sick leave, the 56 hours there, New York City Earned Safe and Sick Time Act, right, the 56 hours that the ESTA law calls for. So you could end up having an employee who has, depending on whether they're a large or small employer, getting 56 or 40 hours of paid sick time. The workers could have 20 hours above that in a given year. The paid sick leave would tackle the 56 or 40 hours, and then paid prenatal leave, the additional 20. So for a total of 60 or 76 hours, depending on employer size. These mandates are also above and beyond an employer who, say, has a really generous PTO policy, right, that is giving 2, 3, 4 weeks of time, right? The paid prenatal leave is meant to go above and beyond those type of policies as well. Next slide, please. This slide gives you a sense of what the paid prenatal leave can be used for, right? So you can see sort of a broad scope, pregnancy-related absences, fertility-related absences, from guidance is provided from both the city and the state on those topics. What is not covered are postnatal, postpartum appointments for the employee. Additionally, spouses, partners, other support individuals, maybe parents, right, of the pregnant individual are not entitled to use to attend appointments with that pregnant individual and use paid prenatal leave. So it is, while a little bit of ambiguity based on how the laws are worded, it is really focused on the individual who is expecting, who is trying to conceive, not any other individual as part of the relationship. So that's the scope of what the paid prenatal leave can be used for. If you go to the next slide, you'll see some more highlights, including that it can be used in hourly increments. At the state level, there is no specific documentation standard. The city law does diverge on this point, and it permits employers to require an employee to provide supporting documentation if they've been out for more than 3 consecutive days. But because the New York State law is more favorable to workers, it is not generally recommended that employers enforce this documentation standard in the city, even though it's technically codified as part of the rules in the ordinance. As far as giving notice from the worker to the company, you can see the standards here. There's reasonable advance notice of no more than 7 days if the absence is planned, which most of these covered absences should be, right? And then if it's an unplanned absence, the worker needs to provide notice as soon as practicable. Next slide, please. So these are a few more key provisions. No obligation to roll over unused paid prenatal leave at year end. No obligation to pay it out if someone leaves the company. There's a confidentiality component, right? You need to keep this information confidential, right? Anything related to the paid prenatal leave absences, and you cannot, as an employer, retaliate against workers for exercising their rights to paid prenatal leave under either the state or the city laws. Next slide, please. So this is New York City only, right? And this is where New York City really goes above and beyond what the state calls for. So New York City has a very robust written policy requirement. It impacts the paid sick leave, the general paid sick time components of the city's law. those written policy requirements have trickled through to the paid prenatal leave law. There is 95% a written policy requirement under the state paid prenatal leave law too, based on other New York State labor law impacting sick time policies. But New York City, 100% slam dunk, got to have a written policy. It's got to say certain things. It's got to be distributed at certain times to workers through a certain mechanism and method. So if an employer is not up to speed on what those obligations look like, either the substantive content or the procedural distribution aspects, feel free to reach out. That's something we deal with very often for our clients. There is also in New York City a balance notification requirement for paid sick time that has trickled into the paid prenatal leave standards as well. So employers are obligated to provide balance notification each pay period to workers of the amount of paid prenatal leave that they have used, as well as their overall remaining balance, their available balance of paid prenatal leave. And finally, New York City has updated its paid sick and safe time notice of employee rights to include paid prenatal leave. It needs to be displayed, in a conspicuous place in the workplace, as well as distributed to employees during onboarding. When it first was rolled out, it also needed to be distributed to current employees as well. And we've got a link there for you to the current notice. Next slide, please. Okay, so that's paid prenatal leave, but let's talk about other amendments to the New York City Earned Safe and Sick Time Act that go live in a little over 2 months from now, on February 22nd of 2026. New York City, we did an article last year on the 10-year anniversary of the Earned Safe and Sick Time Act. This law is amended all the time. The law, the rules combined, and the FAQs have been amended over a dozen times since the law started, right, between those three areas. Always keeping employers on their toes, keeping us paid leave counselors in business, if you would. And when you're looking at what these key changes are, there are some really big ones that are going to be dropping in a couple of months. One of them is an expansion of the reasons for use. The other one is a new mandatory unpaid sick and safe time component that applies to all employers. There are also some provisions modified with respect to collective bargaining agreements for employers that have unionized workers in the city. So let's dive in and talk about each of these for a couple of minutes. Next slide, please. New York City's covered reasons for use, you can see, have been expanded in some significant ways, right? A big one, the city has had closures related to the employee's place of business or their child's school or place of care due to public health emergencies or by orders of a public official. They now have added closures related to a public disaster. That includes fires, explosions, terrorist attacks, all hopefully very unlikely. But one that is not as unlikely are severe weather conditions, right? So closures related to, say, a winter storm like we had hit here in New York on Sunday this past weekend. If schools were closed, if your workplace was closed, that would be a covered reason to use paid sick leave in the city once these amendments go into effect in February. There's also other updates that you can see here. One of the big ones, those bottom two bullet points that I want to flag, you might be familiar with them because they are actually or were part of a related but separate temporary schedule changes law in New York City. So some of these updates were meant to sort of conform the ESTA law and to merge it with some of the temporary schedule changes law components. So both of those absences, including certain absences related to obtaining or attending a legal proceeding related to subsistence benefits or housing for the employee, their family member, or a care recipient, those are generally part of the separate temporary schedule changes law. Next slide, please. So speaking of the separate temporary schedule changes law. So previously, employees were entitled to 2 temporary schedule changes in a given year. This is different than the New York City Fair Workweek law, right? This is a law that applies, generally speaking, to all employers in the city. It is overlapping with New York City ESTA because the ESTA reasons for use were also covered by the temporary schedule changes law. Changes could be unpaid leave or allowing the employee to swap shifts or to leave early, right? Plenty of absence, different options available for the employee in this context. But as of February 22nd, the big change here is that the employer no longer needs to grant the employee a temporary schedule change. The employee can still request one or up to 2 changes per year. The employer has the ability to deny, offer an alternative, or approve. They do not need to approve, right? They do need to respond, though, and they cannot retaliate against the worker for issuing a temporary schedule change request. So taking a lot of the bite, out of this law. Next slide, please. The unpaid leave component, really big deal here. It's going to require policy updates for employers, potential programming updates. In addition to the 40 or 56 hours of paid sick time, it is 32 hours of unpaid sick and safe time that needs to be provided immediately upon hire and at the start of each year. Employers are going to need to provide the paid sick time to workers before the unpaid sick time, assuming they have both available, as long as the employee has not specifically requested to use the unpaid time first. Same covered reasons as paid sick time under the city law, no year-end carryover required. Next slide, please. All right, and then to get us to our last couple of slides in this space, so the CBA exclusions, you can see here that the law has been updated now in terms of determining, right, if you're going to provide benefits in the paid time off space via your CBA, can those benefits plus a waiver get me out from the New York City paid sick leave requirements? The answer will be yes, as long as those benefits are superior to or comparable to New York City paid sick and safe time. But that now will mean not just the paid component, right, but also the unpaid component. So very important for employers that have CBAs in the city to keep this in mind. And if you go one more slide for me, just a couple of reminders again, some next steps, getting those policies updated. New York City has a very robust written policy requirement for employers, as I mentioned, and now needs to be updated to include this unpaid sick time piece. Training your teams to make sure they're aware of these new requirements, and then awaiting other updates from the city like FAQs, model notices, and the like are expected between now and the February 22nd go live date. So that is New York State, New York City. And with that, I'm going to turn it over to Katie to talk us through Pittsburgh paid sick leave updates that are dropping in the new year.
All right, thanks, Josh. So yes, the Pittsburgh paid sick time law has also been amended effective January 1st of 2026. The law was originally passed back in March of 2020 and was amended earlier this year in June, and these are the first amendments to that law since it went into effect. So next slide, please. We will get into a little bit of detail about these amendments. So first, the amendments updated who's covered by the law. So previously and through December 31st of this year, covered employees included employees who performed work in Pittsburgh for at least 35 hours in a year. And starting January 1st, now all employees who work in Pittsburgh will be covered regardless of how many hours they're working. And the accrual rate has also been made more generous. So through December 31st, the standard is 1 hour for every 35 hours worked in Pittsburgh. And starting January 1st, the standard is now 1 hour for every 30 hours worked. The accrual cap is also going to be more generous starting in January. So through December, if the employer has 15 or more employees, the accrual cap was 40 hours a year. And if they had less than 15 employees, that was 24 hours a year. A significant increase starting in January, where the accrual cap will be 72 hours for 15 or more employees and 48 hours for those employers with less than 15 employees. And it's also now clear that the accrual cap is a point-in-time accrual cap. So starting in January, at no point can an employee of an employer with 15 or more employees have the 72 hours at any single point in time. And for those employers with less than 15 hours, at no point in time can an employee have access to more than 48 hours of paid sick time, unless, of course, the employer chooses to provide a higher accrual cap. And we also have some changes to year-end carryover starting in January. So through December 31st, all paid sick leave carries over unless the employer was previously front-loading. But starting January 1st, all paid sick leave continues to carry over, but those carryover caps are higher. So for 15 or more employees, the front load has to be 72 hours, and for employers with less than 15 employees, it has to be 48 hours. Next slide, please. So we also have changes to the usage cap that are coming. Previously and through December 31st, employees could only use 40 hours per year of paid sick time if the employer had 15 or more employees, and 24 hours if the employer had less than 15 employees. And a large increase here, the usage cap for employers with 15 or more employees starting January 1st is 72 hours in the year. And if you have less than 15 employees, 48 hours. And as we discussed a little bit on the last slide, there's also some changes to front loading. Front loading, both before the amendments and after the amendments, continues to eliminate accrual and carryover requirements. But again, the amount that you have to front load is increasing to 72 hours for those larger employers and 48 hours for the smaller employers. So next slide, please. And a couple of other highlights from the amendments. They finally released a new model notice that needs to be disseminated, and that was released on November 1st and is available on the Pittsburgh paid sick leave website. And they've also added a little icon on their website that they will be providing updated guidance soon. So we're certainly keeping an eye out for that updated guidance, and we'll provide updates to you all as needed, and just know that that is coming. And one interesting wrinkle here is that prior to the amendments, the Pittsburgh law and the Allegheny County law were very similar, almost identical. And that made it easy for employers who have employees who either work or live in some combination of Pittsburgh and Allegheny County. But to date, Allegheny County has not updated their law to reflect any of these amendments to the Pittsburgh law. So now the Pittsburgh law is significantly more generous than the Allegheny law. And that raises some practical challenges for employers. So for example, employers with operations or workers that are traveling back and forth, or working both in Pittsburgh and Allegheny County, or maybe they work hybrid, etc., you have to navigate two different paid sick leave standards now. And that, raises a lot of administrative burden with having to track where those workers are, how often they're moving back and forth, how often they're working in those different areas. So please let us know if you have any questions about that. And we're certainly also keeping an eye out for any potential amendments to Allegheny to reconcile the standards between these two laws. So thanks very much, and I will now turn it over to Kathy for some updates in Minnesota.
Thanks, Katie. We can go ahead and jump to the next slide. We are going to breeze through some Minnesota changes pretty quickly here. Minnesota is a law that has been changed a lot. It was originally went into effect in January 2024, so it hasn't been around for all that long in the scheme of things, and we've seen 4 or 5 different amendments in that time. So lots of ongoing changes with the law, and it remains to be seen if there's more to come in 2026. But we're going to take a quick look at what they gave us for this year. So SF 17 was an omnibus bill that in part amended the sick leave law. There are 2 effective dates to pay attention to: July 1st, 2025 and January 1st, 2026. The amendments affecting sick leave law are all shown on the slide here, and the bulk of these went into effect July 1st of 2025. So that includes the notice requirement. This feels like a small change, but worth calling attention to because it is different than what we see in a lot of other jurisdictions, and certainly different than what Minnesota had before. Employers are now permitted to, quote, reasonably require employees to give notice of unforeseeable paid sick leave absences. This is different than the prior standard, the soon as practicable standard, which is more what we see, almost a gold standard in other jurisdictions. not a ton of guidance or clarity around what reasonably require means in this context, and it might not in practice mean much compared to the prior standard, but worth noting there. The documentation requirement has now changed from 3 consecutive absences to being able to require documentation after 2 consecutive absences. And replacement workers, even though employers can't require employees to find or seek a replacement worker when they're using sick leave, there's clarification that employees can voluntarily trade shifts. So that's something that that might make a difference, practically speaking, for your employees. Those 3 all went into effect July 1st. This last one, the advancing paid sick leave bullet point, that's the one that goes into effect January 1st, 2026. And it confirms that employers can advance sick leave to employees based on the number of hours that an employee is expected to work. Now, it's important that if the advanced amount doesn't satisfy what the employee would have actually accrued in that time period, that employers do need to make up the difference. So again, still requires tracking and being aware of what your employees are working after the sick leave is advanced. And that's going to do it for Minnesota. We're going to jump really quickly on the next slide to look at some amendments in Minneapolis. I'll note that both Minneapolis and Minnesota have model notice requirements, and both model notices have been updated with the amendments that we're talking about today. So take a look at how you're referencing those in your policies and make sure that you've got the up-to-date ones there. If you need us to provide those, we can certainly do that. Minneapolis amended sick leave law is going into effect again in just a couple days on December 31st, right around the corner. These amendments largely align the Minneapolis ordinance with Minnesota's sick leave law. So we cover a lot of changes on this slide, but most of them are really bringing it in line with the state requirements, which should ease the logistical burden for employers. So a few things we'll cover super quickly. Covered employees, they've changed the standard to now include employees anticipated to work at least 80 hours. This could be an expansion for some employers. It previously only applied to employees who did work 80 hours. So you might see more people getting included in your eligibility requirements. The accrual cap also changed. So all employers are now required to permit employees to accrue up to 48 hours of sick leave in a year, plus the separate point in time accrual cap. There had previously been a provision allowing employers with 5 or less employees to only provide unpaid sick leave to their employees. That has now been removed, and this all employer standard is what governs. And front loading was also amended under the Minneapolis amendments. So carryover can only be omitted if an employer front loads 48 hours and pays employees for unused sick leave at year end, or employers can opt to front load 80 hours and not mess around with a year end payout. So those are your 2 options to eliminate carryover. If you do anything different, carryover would still be required. And the reinstatement to employees that have separated from your company and are subsequently rehired has now expanded. It was previously 90 days. It's now going to be 180 days following separation. Reasons for use and family members, we're not going to spend time going over what those changes were. I'll just tell you they now align exactly with Minnesota's standards. We also saw the waiting period removed completely. So now employees in Minneapolis can use sick leave as it's accrued without any waiting period at the outset of their employment. And there is a written policy required. And as we said, the model notice has been updated, so pay attention to that. Same with the Minnesota change we saw regarding documentation. Now in Minneapolis, we can request documentation for covered sick leave absences after 2 consecutive absences. And we save the most important for last. There is now a private right of action and penalties available for non-compliance with the law. We've noted here what the administrative penalty range is, but that's a significant change from the prior Minneapolis law prior to the amendments. And I am now going to, I think, pass it back to Josh to talk about Missouri.
Thanks, Kathy. So next slide, please. Missouri's paid sick leave law has been repealed. It was technically in effect for a little under 4 months from May 1st to August 28th. Employers struggle to figure out what they should do, whether to keep those paid sick leave benefits online, if they offer them at all, to discontinue them at the end of August, continue them through the end of the year and the like. So we still are getting some Missouri questions from folks, but know that this law is over and done with. Next slide, please. One more. So Maine amended their paid time off law. Maine is one of the 3 states, along with Illinois and Nevada, with the PTO law. Maine amended the way that their law handles accrual caps and year-end carryover, the interplay between the two. Those amendments dropped in late September of this year. Previously, whatever amount of unused PTO, up to 40 hours, that carried over at year-end, right, could be charged against the next year's accrual. So if you rolled over, as the example on this slide shows, 8 hours of time from one year to the next, the worker would only be entitled to accrue 32 hours in that next year, not the 40 hours, which is the annual accrual cap. That has changed. Now, and this is the case for most of the paid sick leave laws and PTO laws around the country, the carryover amount does not impact the next year's accrual. So it is possible, to the question that somebody asked a little bit ago, that you could end up with someone having a bank of PTO hours under the Maine law that is above the 40-hour annual usage that they are allowed under the law per year. So that is the big change in Maine that started a few months ago. Next slide, please. One more. So Oregon and Washington both have had some recent amendments. In terms of the Oregon paid sick leave law, right, there were amendments that dropped back in September, on the 28th of September, expanding the scope of reasons for use. And then earlier, or just in a few weeks, right, a few months later, weeks later, in May, amendments also passed that would expand the reasons for use again in Oregon. So let's take a look at what those are on the next slide. So you can see the big expansion here for Maine has been starting in just a few weeks from now. The law will now explicitly cover absences related to blood donation. So that is starting off on 1/1/2026. The amendments from September were meant to help align the paid sick leave law and the covered reasons for use based on changes that were taking place with the unpaid and the paid family medical leave laws in Oregon. Next slide, please. Then in Washington, we have additional reasons for use again, one of which started in late July, the other one that starts on January 1st of this coming year. Next slide, please. The changes that dropped on July 27th were now expanded coverage to include absences related to immigration proceedings for the worker or their covered family member. That applies to both the general paid sick leave law and the transportation network specific paid sick leave law. And just a few weeks ago, Washington released updated regulations that, among other things, include what is now considered reasonable documentation for paid sick leave covered immigration proceeding related absences. Next slide, please. And then finally, the big update that is dropping in a few weeks is that the safe time reason for use under Washington's law, which again will apply in Seattle and Tacoma to those localities as well, which have their own local laws, is the safe time reason has been expanded to cover victims of a hate crime, in addition to domestic violence, stalking, and other covered safe time related absences. Next slide, please. All right, here is our CLE code for folks. Give you a second to scan the QR code here. This is necessary for anybody who is looking to get CLE credit for today's presentation. The code is SS, as in Seyfarth Shaw 3012. Again, that is SS, as in Seyfarth Shaw 3012. All right, so you've got the CLE code there for folks. We're going to go on to the next slide, please, and then go one more from there to do a quick outlook for 2026. So we get asked this all the time. What do we think is coming around the corner for 2026? A couple of things. Number one, and most importantly from our perspective, is Virginia. Virginia has passed a paid sick leave law that only applies to certain home health care employers. But that standard, that legislation, that law is looking to already be amended, right? Governor Youngkin's term, Governor Youngkin has vetoed multiple leave of absence and paid leave bills in the last 2 legislative cycles, including paid family leave, including paid sick leave. right now, Virginia has already introduced legislation to amend their existing home health care employer-only paid sick leave law to expand to most private employers in the state. So keep a very close eye on Virginia. Delaware, Hawaii, Pennsylvania, all very possible as well. New York City could look to expand again, it changes all the time, into the PTO space, a la what Chicago did last year, right? So having a combo sick PTO law in the city, that would not surprise me if we see that coming in 2026. And finally, the second half of 2026, when we get closer to the November elections, the midterm elections, pay attention to ballot initiatives that could be introduced in the paid sick leave space. That's how we ended up with Alaska, Missouri, and Nebraska. Missouri didn't end up making it all the way, well, it made it to the finish line, and then it got sent back the other way across the finish line again with its repeal. But pay attention to the November election and potential ballot initiatives in other not seemingly likely paid sick leave jurisdictions that could nonetheless pursue a paid sick leave mandate through the ballot initiative process. Next slide, please. And go one more. So here's a number of resources that are available for you all. We have a premium paid sick leave survey. You can reach out for more information on paidleave@sifart.com that summarizes every one of the 56 paid sick leave laws around the country that we spoke about at the beginning of this presentation. We also have the paid leave mailing list. You can register at the link there, sign up to get all of our legal updates and blog posts and webinars, invites and podcast invites and the like. Next slide, please. We also have this webinar series in its first 16 parts, all available for folks who are interested, as well as our specialized leave of absence and accommodations Take It or Leave It podcast that has 45 episodes available for folks. So with that, I know we are just a minute or so over time, but I did promise we would hang on for an extra second and answer a few more questions from folks that came in. So one that came in that I saw about New York City was whether the unpaid sick and safe time component that starts on February 22nd will apply to exempt employees. And the short answer is yes, right? It will apply to any employee who is eligible for New York City paid sick and safe time today. It will also apply to those individuals as well. So that includes exempt, non-exempt, full-time, part-time, temporary, per diem. The law has very broad coverage, very few exceptions under the New York City paid sick time law. There's a question about Pittsburgh, which looks at employee count, right? How you determine whether you are a large or a small employer in Pittsburgh and whether the employee headcount only counts employees who have operations, only counts employees who work in the city, or if it's broader and counts more employees, including those outside of the city. My understanding, and Katie, correct me if I'm off base here, is that Pittsburgh counts all employees anywhere in the country, not just those within the city limits, for determining whether you're a large or small employer. Is that your understanding too, Katie?
Yeah, that's my understanding.
Yeah. Okay. So, and that's fairly common, folks. From a paid sick leave law perspective, there are some Connecticut, although that's winding down because they're going to soon be covering pretty much just having one person in the state. But for a long time, Connecticut, Nevada, right, Alaska, right. So some of these laws do have looking at only the workers within the jurisdiction, but a lot of them don't. A lot of them where you have a tiered approach for accrual or usage caps or accrual rates or whatnot will apply based on your total U.S. workforce count. So it's one of the bigger frustrations with the paid sick leave law world, among many. A final question that we'll tackle before we drop for today came in, which is a good one, a complicated one. The question was from John asking about an employer that provides 160 hours of PTO per year, very generous PTO policy. How do we handle the unused time at year end in Nebraska and Alaska, where there's no cap, technically speaking, on year end carryover, right? And what I would say here, while there's a lot of wrinkles and nuance to this, one of which is don't forget about the Nebraska unpaid, or excuse me, the Nebraska vacation time no forfeiture law that prohibits employers from forfeiting earned unused PTO, vacation, personal time, the like, both at year end and at separation, right? So that needs to enter the mix in Nebraska. But if you're thinking about the paid sick time laws, right, this is something that a lot of employers will need to work through their own internal risk tolerance assessment, right? Is it worthwhile to carry over the full amount of unused time, even though the law only requires that we let them use 56 hours per year? Do we want employee balances to reach 200, 300, 400 hours, fast forwarding a few years down the road? Won't that get confusing in terms of reporting available balances to workers? Can our system even account for that? Right? So there's a sliding scale that we talk through with clients in jurisdictions like these two that have no cap on carryover, or that have a cap on carryover that would result in the worker potentially having a greater balance of time than what the law allows to use. And for every company, that sliding scale of risk tolerance is going to be different. But that's how we typically will handle these topics, and that's how I recommend this company do so as well. So, with that, thank you so much, everybody, for joining us today. If there are more questions after folks have reviewed the slides or have spoke to their internal teams, here's our contact info. Always happy to chat about these topics. There's a lot of moving pieces. So thank you, everybody, for joining us today. Wishing you all a very, very happy holiday season and healthy new year. Thank you, everybody.